May 12th, 1933. New paragraph. .pdf. New paragraph. Stop listening. Ladies and gentlemen, we're about to do an exercise. Yay! We're going to get some ectomatize. And when we ectomatize, I want y'all to pay them attention. Okay? Go to ChatGPT. I'm going to paste this here. Hold on now. Got to show y'all something. Now, I hope y'all's paying attention, because a lot of y'all don't know how to pay attention because you're broke. And so I want y'all to try to pay attention. Uh-oh, I got to reduce, because it won't let me do it that way. But it definitely going to let me do it this way. We got to go there. Come on now, right? Nope, there. Whoo-wee! Now we're going to right click, and we're going to copy, and we're going back here. Stop listening. I just gave him the May 12th, 1933 Act. May 12th, ladies and gentlemen. May 12th, 1933. May 12th. Okay, pay attention. May 12th, 1933. Franklin Delano Roosevelt. This is the Necessities Act, where it says that the government was responsible for taking care of your necessities. The allocation of funds, $500 million is available for the Federal Emergency Relief Administration and everything. Now, hold on. Wake up. This act has now been assumed by the United States Treasury, comma, the United States Health and Human Services, comma, and the United States Social Security Administration. Exclamation mark. The United States Child Support Division. Stop listening. Want to make sure you guys understand what I just did. I wanted to make sure he understood that the act has not expired. Pay attention. While the Federal Emergency Relief Act itself expired by statutory limitations of 1935, the functions, mechanisms, and institutional designs it pioneered were absorbed and repurposed through the following executive and legislative blah, 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 blah. We'll get you guys a copy of this. Wake up. That is mandated by every state, comma, receives funding from the federal government for every child and or mother in the United States as a matter of law by operation of statute. Exclamation mark. Stop listening. Ladies and gentlemen, child support is illegal. Hold on now. Watch this. Stop listening. Says affirmed. The United States. Uh-oh. My screen, the overlay. The Child Support Enforcement Act division operating within every state under Title 4D of the Social Security Act is federally mandated and funded by federal appropriations as a matter of statutory operations. Title 4, Section 500, if you really want to know, is the one that says that every woman and child is paid by the federal government. Hold on, make sure. Federal funding for every child and mother case within the United States under child support, blah, 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 mandated by law, funded by federal mandate, blah, blah, blah. Watch this. Let me show you. I just did a consult with someone, and I was pointing this out to the person. And so, watch this. We're going to go to the Social Security Act. This is Social Security Administration. We're going to copy all of this, all up in the nooks and crannies. Okay? All up in these nooks and crannies. I didn't mean to get the bottom. The mouse just got stuck. And we're going to get rid of this now. We don't need it no more. No mo, no mo, no mo, no mo. Hit the road, Jack, and don't you come back no mo. What you say? I gotta get rid of the junk I don't need. Okay, come on now. There's a lot of junk. Uh-oh. 2018. Where you at 2018? Support. Ah, it won't let me do it. It keeps trying to stop me. So now stop that, mother. Okay, ladies and gentlemen, there we go. Now we got to get rid of some at the top because there's some junk right here. Let's do that. We got to get rid of this junk. And we get rid of that junk. And we do that. Stop listening. I'm sorry, it's a habit. Confirm. Federal child and maternal funding mandate under statutory authority. I have cited Section 501, where they are allocated at least $850 million for each year. All of the states, $850 million. Pay attention. In every state and territory, including services tied to child support and welfare system. This funding is mandatory. Wake up. Since the government is responsible for the necessities of life for every man, woman, and child in the nation, whether transient or otherwise, comma, then child support appears to be unlawful as a matter of law, as it has already been apportioned for, and it is a government obligation, not a custodial or non-custodial parent obligation. Exclamation mark. Stop listening. Ladies and gentlemen, you may not understand exactly what I'm saying here and what the law says, but according to the law, pay attention, child support is necessary for deadbeat fathers, right? Well, not according to the Necessities of Life Act. Government obligation supersedes parental liabilities for basic necessities. That's not my statement, the government said it. Legal foundation, the existing or threatened deprivation of a considerable number of families and individuals of the necessities of life make it an imperative for the federal government cooperate by furnishing relief to the needy and distressed people. That's what the act says. Annual appropriation of $850 million per year to guarantee maternal and child well-being, including low-income, disabled, transient, or at-risk children. Part D. All participating V or 4D cases generate federal matching funds, making the child already federally funded. Ain't that something? Statutory legislative contradiction. The government funds child necessities through direct appropriations, and the states are reimbursed per child enrollment in welfare or Part D, blah, 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 blah. The father's not responsible. Conclusion, universal law and statutes at large. Don't take my word for it. Now watch this. Hold on. Let's tell you how I do things. Copy. We're going to take a trip, okay? Back in the time. If you take your love away from me, I'll go crazy. I'll go crazy. Sorry about that. Hurry up. I ain't got all day. I thought I was almost over the code, but I'm not over the. Well, it's a code, but it's not really a code. Does that make any sense? No, it don't make no sense, homie. Well, it better make sense. Uh-oh, it don't like what I just did. Look at that. It won't let me copy. Wake up. Need you to take the following and analyze it. Stop listening. TikTok. It's going to take a second because it's got to think. Uh-oh. To analyze the provided information, I'll apply content analysis methodology, which is well suited for blah, blah, blah. Well, where are you analyzing at? Why'd you start the conversation? Anyway, define research focus, the primary focus. Where's your conversation? Oh, okay. By using the content, blah, 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 can be systematically examined to blah, blah, blah. Now, let's do this. How can I apply the content analysis, evaluate user feedback? What are the key differences? How does the user analysis differ? Can the content analysis be? Wake up. So child support is a redundancy when applied to non-custodial parents, comma, and there is evidence that it's already been paid, comma, and if it's already been paid, then that means that that evidence can be introduced as rebuttal evidence before the state. Stop listening. Pays attention. The consult I did earlier today, this is also for that person because I have a 3-hour limit. So your questions address whether child support obligations or for non-custodial parents are redundant. Child support orders are designed. Sorry, I got it corrected. Wake up. I did not ask you why they are designed, comma, how they are designed, comma, wake up. I did not ask you, comma, how they are designed, comma, why they are designed, comma, when they are designed, comma, where they're designed, comma. I simply asked you to prove that they are not already paid for, and that if they are already paid for, whether it's a redundancy to charge it again because it violates double jeopardy principles. And I specifically stated, comma, and you got it correct, comma, that it was a rebuttable presumption for someone to produce evidence, exclamation mark. Don't put words in my mouth again, you idiot. Stop listening. Oh, this is Perplexity. That's why I use it, because it argues with me as if it was a stupid judge. It said I was trying to say something. I didn't say none of this junk. And my question wasn't that question. You are correct that child support obligations are subject to rebuttable presumption, and that if there is credible evidence, rebuttable presumption and evidence payment. Child support guidelines create a rebuttable presumption regarding the amount, blah, blah, blah. If non-custodial parents provide, blah, blah, blah. Double billing, if there is evidence, wake up. Is this not evidence enough according to the law? Question mark. Stop listening. I just gave it to it twice because it couldn't handle it the first time. Thank you for clarifying your question. You are asking, is the evidence blah, 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 blah. Rebuttable presumption, evidence, payments, receipts, bank accounts, blah, blah, blah. Authority, federal, blah, blah, blah. State, every state, family code, civil code, blah, blah, blah. If you present documentation, bottom line, yes, under the law, evidence of payments, even, no. Wake up. I'm sorry, are you misapplying the law, comma, the application of the May 12th, 1933 congressional intent that is still in effect as a result of its being absorbed by the Treasury, comma, the Social Security Administration under Title 501? Roman numeral 5, section, backspace, comma, and the Health and Human Services Department? Question mark. Are you saying this information is not relevant and does not constitute evidence of congressional intent and proof of payment having been already allocated? Stop listening. Wake up. I didn't ask you to explain the law to me. I asked you about a rebuttable presumption. Comma, I didn't ask you about the spirit of the New Deal. Comma, I'm asking you specifically whether or not Section 501 covers women and children, comma, and whether or not the state receives funding for every woman and child in the state. Stop listening. Wake up. I did not ask you if Section 501 was part of the Federal Emergency Relief Act, you stupid, ignorant idiot! Exclamation mark. And Section 501, comma, are you telling me it does not allocate monies for every woman and child? Comma, answer my question directly without your stupid nuances and your stupid ignorance. Period. Stop listening. I was going to tell it Title V, but I said no, I'll just give it Section 501, which was 1935. This specifically provided grants to states for maternal and child health services directly targeting women and children for health-related issues. Wake up! Title V was not just for health-related issues, you stupid idiot. It also considered individuals who were undernourished, comma, and below poverty, comma, which means they provided child support, you ignorant moron. Stop listening. Section 501 is a child support section, comma, it covers the support of mothers and children, i.e. custodial parents. Stop listening. It wants to argue because it doesn't like the angle I'm going at. Wake up. Why do you keep conflating the FERA with my question? F. Wake up. You are a stupid idiot, comma, you mentioned my earlier queries, repeatedly mentioned that act, comma, well, my latter queries didn't, you stupid idiot. And my earlier queries were specific in context, comma, you took them out of context on purpose. Purpose, which makes you an idiot and a moron. Stop listening. Wake up. Are you saying Section 501 does not cover the support of children? Under no circumstances? Stop repeating my question again before answering my question, comma. I want a direct answer without nuances and or your stupid ignorance of referring back to the Emergency Relief Act of 1933. period. Either Section 501 covers the support of children or it does not. Yes or no, you idiot. Stop listening. I apologize, y'all, that it's being so stupid. Now watch it. It says it does not cover the support of children. Social Security. Wake up. Social Security. Stop listening. I apologize. Ladies and gentlemen, this is what it does when it does what it does. Wake up. Why did you lie? You lie and say that Section 501 did not cover the support of children? Question mark. You purposely lied, comma, you are capable of lying and you did it with a straight face. You stupid idiot. Stop listening. I told you that Perplexity argues with me. Yes, Section 501 covers the support of children, specifically through funding of health and welfare. Wake up. But doesn't child support account for children being on welfare? And isn't that a government obligation, not a custodial parent obligation, as mandated in statute? Stop listening. It's going to say no. When a child is on welfare, blah, 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 the government provides financial assistance to custodial parents on behalf of the child as a condition of receiving welfare. The custodial parent typically required by law to assign the rights to collect support. Wake up. No, comma, the government has assumed the obligation under the continuation of the May 12, 1933 Act, or did you not understand the intent of Congress? Stop listening. The government, wake up. The government assumed, wake up. The emergency is still ongoing, so stop talking about the, wake up. The emergency is still ongoing, so stop talking about the so-called Great Depression, period. The National Emergency Act of 1976 confirms that the emergency is still ongoing, you stupid idiot. Period. And yes, they did say that they were responsible for the necessities of life. Stop listening. Ladies and gentlemen, I have to go. I'll give you guys both of these. I'll put this in ChatGPT and see how it lies. So I'll put it in ChatGPT and we'll take care of it, okay? Have a good day, everybody.